All right, welcome to our class on copyright. So today we'll be reviewing the laws around copyright and how it applies to works of art, works of expression, particularly in dealing with businesses. So let me start here by sharing my screen, and we'll start here with just an overview of copyright. As you read, this is an intangible property right. Now contrast that with just a couple weeks ago when we were talking about the UCC and sale of goods. Well, goods is something different, right? That by nature is tangible and movable. Now we're dealing with things that fall outside of that, obviously, and this is one of those intangible rights. And I've mentioned this before in the class, but the value of intellectual property, of these intangible rights in the US tends to outweigh the value of the actual physical property. And this makes sense to you. I think if I told you that you were going to buy Facebook, well, Facebook owns a lot of tangible assets. It's got that cool new building. Well, and Apple has that new like circular building. Well, Facebook has all of these amazing locations, office spaces, servers. Um, yeah, I mean, kitchens, you name it. Like Facebook owns a lot of property. But if you added all of that up, it might be worth, I don't know, $500 million or something. Maybe $1 billion if you add up all of their office spaces. But you and I know that Facebook is worth much more than that, many billions more than the sum value of the physical assets. And why is that? Well, it's because of intellectual property, some of which is going to be copyright material, copyright protected material. So it is their code, it's their algorithms. Now, some of that's going to be trade secrets, some of it's going to be copyright, some of it will be patents. But again, it goes to show you that the value of intellectual property actually is more than the value of the physical assets. And that's true not just with Facebook, but with many companies. As we discussed in class, though, one of those is not carnival food trucks. Like the value of a carnival food truck really is just the food truck and whatever other assets are involved. But again, here with copyright, we're talking about artistic productions, literary productions. You understand copyright typically, like when you think of copyrights, you probably think of books like this. And you would be right. If you write a book, if you write a short story, if you draw a picture even, you will get copyright protection for that work that you created. Now, in general, kind of look to, if you create something, then that copyright protection lasts not only during your life, but 70 years thereafter. And as you read, this hasn't always been the case. It started off like 20 years from the date of creation, just like patents, and it has steadily increased much thanks to Mickey Mouse, right, and the Disney Corporation lobbying to extend those rights further and further. And I won't get into that story because you read it, but I think that that's important. Also important is Disney has said that they aren't going to lobby to extend copyright protection any further, meaning the Steamboat Willie cartoon that Disney put out will shortly be coming into the public domain, meaning you could show that short clip, that film, at a party, at a ward function, for example, and not worry about getting sued for copyright infringement. And anyway, that's important because you probably saw stories. This was just, what was it? early 2020 that a school PTA, a parent teacher association, was doing a fundraiser in California and played The Lion King. And the rights holder, the copyright holder, found out and fined them $750. Now, the CEO of Disney was kind and I think paid that fine for them. But it goes to show you that there are risks associated with public displays of other people's copyrighted work. So this bottom paragraph on this slide, however, is just talking about how if it's published by a publishing company and the publishing company owns the copyright, then it's 95 years from the date of publication typically, or 120 years from the date of creation. But usually you're looking at about 95 years from the date of publication. Now, I like to share this next slide with my class simply to talk about a painful part of my life. Okay, so if you aren't familiar with what this slide is showing, these two actors were the stars of a show that started on the BBC a number of years ago called Sherlock. I think it was called Sherlock. And Benedict Cumberbatch is this tall fellow here. Anyway, my wife Laura and I, we got really into this show. Like it's actually an amazing show. It's usually like 3 episodes per season, but they're more like movies that like they're an hour to an hour and a half long each episode. And so, and they're just amazing, like really intelligent. You have to pay attention the whole time, catch little details at the end, everything comes together. Like it's just a great show. And so my wife and I were watching this, and anyway, this was a couple of years ago, and we were finishing the last season, and I said something like, man, like go BBC. I mean, they're not afraid to cast the ugliest man in the world as Sherlock. And my wife looks at me like, excuse me? And I didn't know how to, I was like, yeah, I mean, Benedict Cumberbatch, like hideous. I mean, just horrifying. And I thought my wife would agree. Apparently my wife has terrible taste in men. I know, that's depressing. She fought me on this. She really feels that this is a good-looking man. And so this is something that we're dealing with and we're working through. Your prayers would be appreciated. Nonetheless, I bring this slide up not just to talk about Benedict Cumberbatch, but to talk about the legal issues, specifically the copyright issues involved with the show itself. And so what happened is when Sherlock was produced by the BBC, the copyright protection in the United Kingdom had passed. The UK just hasn't been extending copyright protection as much as the US has. And in fact, I don't think any country has copyright protection extending as long as the United States does. Where this is something, again, we've gone it alone here. And so by the time the BBC produced and aired the shows of Sherlock, there was no more copyright protection for Sir Arthur, dang it, screwing up his name, Conan Doyle. Arthur, yeah, not author, Arthur Conan Doyle. And so they could create stories based on the books, derivative works as well. All of that was fine in the UK. The problem occurred when BBC wanted to air those episodes in the United States. And they do this through BBC America. And anyway, they want to do this because the US is actually the BBC's biggest market. And so, yeah, you can make money in the UK by producing and airing this in the UK, but really, like, you kind of want to get it to America because that's where you can just make more money. The problem was, of course, that some of the Sherlock works were in the public domain, meaning you could make a movie about it, hence derivative works, without any concern. But not all of them. And so to help me kind of explain this, I'm going to pull up a whiteboard here and just kind of show you. Here we've got a timeline stretching back from, like, we'll just put creation of this right here is let's call this the first creation of Sherlock. All right, so this time period right here. All right, and in the United States, now as you know, copyright protection is a little bit complicated because it continues to be expanded and changed. So let's just understand that in the United States, it wasn't the life of the author plus 70 years for all of these works, because then all of the Sherlock works would come into the public domain at one time, like you die and then you count 70 years and that's when it is. The way that the copyright regime that this was working under was basically a time period, something like 70 years from the date of creation. And so a lot of these works started coming into the public domain, late 90s, early 2000s. So let's just say this is 2000. And let's say that this is the first books. This is the copyright protection. This right here, we're going to call this, here, let's call this copyright protected. It's red. Don't mess with it. But here, you can now use it. We'll just call this the public domain. All right. All right, but that's the first book. Then there's another book here, another book here, another book here, extending all the way. I think the last Sherlock work finishes over here in 2022. Okay. So again, you've got all of these works with their associated public domain time period. Like they're all entering the public domain a year or two after each other. And again, the very last one comes into the public domain in 2022. So, but the BBC show, I think that started around 2010, 2011, somewhere in here. And you see the issue. We've got some books that are still copyright protected here, and some that are still protected out to here. Okay, so stay with me. Now, Sir Arthur Conan Doyle has passed away. Like, if you didn't know this, he's passed away. But it doesn't mean your copyright protection ends, obviously. It can last beyond death. So it's owned by your estate, by your heirs, basically. Now, Sir Arthur Conan Doyle had kids, grandkids, great-grandkids, and now great-great-great-grandkids or something. And all of those people are interested in royalties from licensing out the works of their great-great-grandpa. Let's just call him great-grandpa for our purposes. And what the BBC did is not give them any money. Now, some of you are familiar with like the Sherlock movies. These are the movies that, what's his name? Iron Man. Yeah, that guy that he did. So he's done a couple Sherlock movies. I think there's rumors that another one's going to come out. And what did Universal or whoever produced those movies do? They paid the heirs. They just said, look, like, you know, we'll give you a certain percentage, 1% of whatever the movie makes or whatever it is that they negotiated. And the heirs like that. They've been living off of great grandpa for a long time. It's their family business, is licensing out the Sherlock works. And I'm sure that they aren't happy that gravy train is about to end, the last one being in 2022. But the BBC didn't do that. The BBC said, nope. Remember, this is the BBC line right here. This is when they started creating those TV shows that are more like movies. And the BBC said, like, no, we're only going to take from storylines and works that are already in the public domain. Now, the heirs that wanted this sued in the United States and sued the BBC, technically BBC America, for copyright infringement, because their argument was, yeah, you may only be taking from storylines over here that are in the public domain now, but, and sorry, that circle should not extend over there, since this is when it first started going into the public domain. So BBC's defense was, look, we're only operating right here. Everything here that's in the public domain, that's all that we're using. Now, the heirs said their legal theory was, and you could like think about it for a second, you can even pause it and like brainstorm yourself. What would they argue to get around this? Okay, well, their argument was, sure, you may only be using source material that's in the public domain, but you're using the persona of Sherlock, which isn't contained just right here in this blue circle. It's contained, let's use red here. It's contained in all of this. All of this is, in essence, the persona of Sherlock and Watson and the other characters. And so, yeah, the source material's here, but again, I think you get their argument that you're still infringing on our copyright by using the persona of Sherlock that has been developed over many years, some of which, some of those works are still in the future and aren't in the public domain anymore. Well, they lost. This actually got appealed up to the Supreme Court. I think it was Justice Kagan that dismissed it and said, sorry, like the gravy train's over. In essence, she didn't really say this. Basically, hey, heirs, it's time for you to get a job. Okay, like go forward with your life. And that's how it ended. BBC ended up winning that litigation and was not required to pay royalties to the BBC for, or wasn't entitled to royalties from the BBC for the production of That Hideous Man that I just had on the screen. All right. Okay, so let's not look at Benedict anymore. Let's go back to just some basics about copyright law. So again, copyright law protects you, protects owners of copyright against not only the reproduction of the work, which I think you get. Like if you wanted to, I don't have it up here like some other books that we have, but if you wanted to just, copy word for word that marvelous literary masterpiece known as Twilight, well, obviously that's a reproduction of the work. That's that's obvious infringement of somebody else's copyright. The author, I can't remember her name, studied English at BYU a few years before me, and she's made money off of vampire love stories. So cool. If I wanted to reproduce that, just copy it and sell it in my own book, because I think the paperback is tacky and it should be in a nice leather-bound set that will last forever. Like, I just can't do that. I would be reproducing the work. Obviously, can't do that. Now, development of derivative works. So this is where we can have kind of a fun discussion about fan fiction, for example. So think of like Harry Potter deals with this. J.K. Rowling has to deal with this often. Somebody wants to write a book that is called something like Hogwarts, Harry Potter's 9th year, or whatever, because he had to go back to school after everything. Okay, whatever. And so somebody writes a new book about Harry Potter, or Harry Potter, his first year at a desk job or something, right? Like that's derived from the storyline and the Harry Potter copyright, the books and everything else that J.K. Rowling has put out. And so that would also be copyright infringement, because again, it's derived from copyright protected work. So again, that's important to keep in mind. Now, sometimes authors will give permission for derivative works. It's a way for them to kind of build up fan support for what they're doing. And yeah, it's free marketing. It's still, but it's copyright infringement unless that permission is given. So you do have to be careful with this. And yeah, your fan fiction site could absolutely get shut down on this basis. All right, distribution of the work. So again, selling, marketing the works. You can't do that unless you're the copyright owner or have received permission to do so. And then public display of the work. So that's the Lion King fundraiser that you see down here at the very bottom. IBC companies, this is one of my pet peeves. IBC companies around campus, they'll want to sell hot dogs there at the entryway to the Smith building. And so they'll be playing music from Coco or whoever, Backstreet Boys, what? And again, that is copyright infringement. They're playing with fire by doing that without permission. And there are simple ways to get permission. Go through a music licensing company. Target does this, Walmart does this, Sam's Club, Costco. When you're shopping and you hear music playing, it's because Costco got permission to do that. All right. Okay. Now, what is a protected expression? Because as you know, copyright protects artistic expression. So to help me with this, what I'm going to do is I'm going to come back over here to here we go, to my whiteboard. And you may not know this about me, but I am an artist. Okay, so I am going to draw. Let's do a monkey today. All right, so I'm going to draw. This is basically a Bob Ross tutorial. All right, so I'm going to start with the face. All right, and monkeys, as you know, they have a little hair up top. I believe they have some ears. And monkeys have huge alien eyes. A little nose, I think. Most monkeys have noses. And of course, a big smile. What the heck is happening here? All right, so here's my monkey. All right. And that's a tail with two stubby legs with little feet. Oh, has arms too. Let's do this. Do monkeys have eyebrows? I don't know. Well, this monkey has a unibrow. All right. Again, here is, I think they have little stomachs and fingers. All right, this is basically the greatest thing that you have ever seen in your life, or frightening. This may haunt me. I'm trying to come up with ways to make this a happier monkey. Maybe cheeks. Mustache. Okay, whatever, I'm gonna stop. You get the point. I've got a monkey here, and the question is, do I have copyright protection in this monkey? Okay, so what do you, I want you to think about it. Have I created something that can be copyrighted, that can receive copyright protection? And I want you just to kind of go through the list of requirements here. One that's important here that I want you to be thinking about is, let me come back to some notes here. With my monkey, does it fit one of the criteria? Is it artwork? Well, you may be thinking, that's debatable, but that's amazing. So it fits one of the categories. Technically, it's art. It's something that I drew. Now the other requirement is that it be fixed in a tangible medium, and so I want you to think about that for a little bit. Was the thing that I drew, let's say, pretend that it was just on your typical whiteboard on campus, like if we were in a physical face-to-face class today. Is it fixed in a tangible medium? Well, fixed means, it's placed, it's there. And a tangible medium, well, you know what tangible means now. It's you can touch it. And so is that done? And the answer to that is yes. Now, some of you are thinking like, what? Like if it's on a whiteboard done with a dry erase marker, it can just easily be, somebody could come up as they are cleaning the room one night and, accidentally erase part of it or all of it, like they do one of these things. And I know I'm kind of actually sad to see my monkey go. And poof, it's gone. And so you're like, how tangible was this? Like how fixed was this? Well, again, with that, it's just, was it fixed at a specific time? And the answer is yes. And once it is, well, then it receives copyright protection. This is interesting. That monkey that I just drew is copyrighted. All right, probably more accurately, I should say, it has copyright protection. And what does that mean? Well, it means I can, if you saw it and you liked it and you took a screenshot of it off of YouTube or wherever it is that you're watching this, and decide to put it on a shirt and sell it, and maybe next semester your IBC company is going to be called, Hales Monkeys Hot Dogs IBC. That's the worst name ever. But if it was, well, I'd sue you. Like I'm just going to come clean. I'm going to sue you, and I'm going to get a certain percentage of your profits. Why? Because you infringed on my work. You infringed on something that I created. Here, this next slide just kind of goes over all of the things that can be protected. Even sound recordings, architectural works, pantomimes. As long as these things are fixed in a tangible medium, then they're going to be protected. All right, and if somebody infringes on your copyright, then you sue them. So again, this is important here. Infringement occurs when a party copies all or a substantial amount of a copyrighted work without the owner's permission. All of this is fairly simple. Direct evidence is easy, like you put it on your t-shirt for IBC, I'm going to sue you. But indirect, this is a little bit more interesting. Like, let's say that you didn't copy it outright, but you used it as the inspiration or whatever for your new work, your new artistic expression, whatever that means in a specific circumstance. Well, here I don't have to prove that you directly copied my monkey. All that I have to prove is that you had access to my copyrighted monkey and engaged in sufficient copying to establish substantial similarity. This language right here, I love. You accountants in the room are like freaking out. You're like, what the heck is sufficient copying? What is substantial similarity? Again, let me make it easy for you. It's as long as you copy 46.3%. I'm kidding. Don't follow suits in that. Like, throw that out of your mind, or what your high school teachers told you. Like, oh, you can copy about 2 pages in a book or something. No, sufficient copying to establish sufficient similarity. What does that mean? We're going to ask a jury to decide that. And you read about this with the Lana Del Rey and the Radiohead song. Now, I've got to tell you, I was a kid in the 90s. If you turned on the radio in the 90s, you heard Radiohead, and especially that song, Creep. You heard it all the time. And I checked it out. Lana Del Rey is my age. So she and I went through the 90s together. We survived the 90s, the, baggy cargo shorts, really massive skater shoes. Like we survived that, okay? And Radiohead was included. And so she heard it. Okay, so that, like, looking at this bottom bullet point here, did she have access to the copyrighted work? Yes. Like I said, if you had a heartbeat in the 90s, you heard Radiohead. All right. Now, did she engage in sufficient copying to establish substantial similarity? Now, this was interesting because in that article, you could listen to both. You could listen to Radiohead's song, and then down below, you could listen to Lana Del Rey's song that, let's just say, borrowed heavily from the underlying beat and chord progression. Like, I'm obviously not a music person, but when you listen to those two songs, you're like, it's not the same song. Lana Del Rey slowed it down. She made it more depressing than what Radiohead did, which was pretty difficult to do. And yet somehow she found a way to make it even more sad. And yeah, after I listened to those two songs, I thought, yeah, the similarity between those two is substantial. Now, again, don't try to put a number to that. It's just, we're going to let this go to a jury. And I think it's been 3 years now. It was Robin Thicke got sued by the estate of Marvin Gaye for doing the same thing with a song called Blurred Lines. And again, it went to a jury. The jury found for the estate, basically the children of Marvin Gaye, and they won a substantial amount of money from Robin Thicke for that Blurred Lines song. So lots of times we just kind of let this go to a jury. Use your common sense. Would a reasonable person say that there's sufficient copying to establish substantial similarity? All right. And this leads us to the end here about fair use. Now, fair use is something that you've heard probably ever since your high school teacher told you incorrect things about copyright infringement. And so you probably have heard false things about fair use as well. What you need to understand and realize here is that fair use isn't a get out of jail card. Basically, I want you to understand that once copyright infringement has been found, so basically like if you're accusing me of copyright infringement, once it turns out that I am found to be a copyright infringer, fair use is my defense. It's a defense against a claim of copyright infringement. So again, this is written into the code itself, and that's where this quotation comes from: the fair use of a copyrighted work for purposes of criticism, comment, news reporting, scholarship, or research is not an infringement. So yeah, you've been found to be an infringer, but you're going to use fair use to get out of it. Here we look at these four characteristics, or these four factors, I should say. And these, I want you to think of it as a scale. If on this side, this is, let's just say that this is copyright infringement, and this is fair use, get out of jail kind of. Then what we're going to do is look at this, the purpose and character of the use. Is it commercial or non-commercial? If it's commercial, if you're copying the other person's work to make money, well, that looks more like infringement rather than fair use, right? So we may weigh a little bit like heavier over here if you're trying to make money off of it. The nature of the work, the amount and substantiality. Again, if it's a lot, that looks like infringement. If it's just a tiny bit, that looks like not infringement. That looks more like fair use exceptions. The effect of the use upon the potential market. If this is going to take money away from whoever the copyright owner is, well, again, we're going to weigh that more towards over here towards copyright infringement. So So you'll just kind of go through all of these, kind of weigh it out in your mind, and then decide whether or not it's whether the fair use defense is going to be effective in this, or not, or whether it remains copyright infringement. So let me get out of that, and let's do a little bit of Top Hat, just so you can kind of see what's going on here. Oops. Get me out of the way. Okay, so here I'm going to just allow you to kind of go through this with me. All right, a copyright comes into existence. This one's relatively simple. This isn't a real application question. Just when do you get copyright? And obviously, you know this now. Once the work is created in a tangible medium. Okay, you don't have to register it to get the copyright protection. Unlike patents, remember last class when we talked about patents, in order to receive a patent and rights and protection for your invention, now, and again, this is new, now you have to go get the dang patent. That's how you protect yourself, is getting the patent. But not so with copyright. You have copyright protection once it's created in a tangible medium. That's when it is created. Now, to sue somebody, yeah, you have to register your copyright, but you can do that after the fact. Okay, so again, that's why B is not going to be correct. When the author provides notice by putting a copyright notification on the work, I always love this one. No, you don't have to do that. When I made my little monkey, I didn't have to put the little C with a circle around it. Not necessary. It's created in a tangible medium. All right, and then when the work is infringed upon, that one doesn't even make sense. Like you don't have a copyright until somebody infringes. Again, that makes no sense. All right, this one's a little fun. This takes me back to my church dance days many years ago, and for some reason, every church dance in LA loved to play Weird Al's Amish Paradise. Of course, it's a parody of Coolio's Gangsta's Paradise. And just a side note here, I saw an interview with Weird Al, who's still coming out with music, by the way, which is amazing. Like, I thought he was way old in the 90s, but he said something to the effect that he's always received permission to do one of his parody songs. And anyway, but let's say that he didn't. Let's say that Coolio didn't give him permission, and he made Amish. By the way, look this up on YouTube if you haven't yet. Amish Paradise is kind of so stupid that it's kind of funny. All right, so he doesn't get permission. And so, yeah, the question is Weird Al's use of the song. And let's go through these. Could constitute defamation if he makes Coolio look stupid in the video. Is that really defamation if you make somebody look stupid? No, let's throw that one out. All right, could be copyright infringement if you used the full tune of the original song and changed a few of the lyrics slightly. Let's hold on to that one. Like, let's come back to that, because that could be interesting. C, would be legal misappropriation. Well, this isn't an appropriation thing. It's an infringement thing, so let's throw C out. Would be legal under fair use because all parodies are automatically exempt under fair use. All right, in class, about half of you would pick D. But I want you to, here's a couple test-taking tips, right? All parodies are automatically exempt under fair use. Like this is a strong language and a bunch of statements that just aren't true. All parodies are not given automatic protection. That's not how this works. And a lot of that is because of, like, if we jump back to B here, if you use the full original tune from Coolio and you only changed a couple of the lyrics slightly, well, that looks more like a derivative work or just direct copying. That's infringement. All right, so that's why we're going to say B is right here, because D can't be right because all parodies, like, you can't just say it's a parody. Fair use. Get out of jail. A parody has to be much more involved than that. Okay, so again, not all parodies, because some parodies can fall under copyright infringement because of B. Like, if you're not changing that much, it's going to be copyright infringement. All right, so I hope that helps. Again, let me know if you have any questions, and I'll look forward to seeing you next time.